Early after I was called to the bar, I was served as the counsel for a wife in a matrimonial matter with a summons to a witness, the witness being a surgeon who had operated upon my client. I had blithely prepared an affidavit in support of a interim motion for support where we deposed to her having had cancer and being unable to work and therefore solely dependent for support upon her husband. And the technique employed by counsel for the husband, rather than to cross-examine my client and have her reiterate all of the legitimate health concerns that she had, which we said made her unable to work, the summons was served on the doctor returnable at his hospital. He was assured that it would take only half an hour and that he was just being asked to talk about how successfully he had cured my client from cancer. And because it inconvenienced him only a little, he was only too happy to cooperate in that respect and gave evidence that there was the cancer was in remission and that there was nothing preventing her from working. Now, that case ultimately settled and she subsequently died. But the result on the interim motion, I think, was substantially better for the husband than it would have been if some other method was employed. And I've been surprised since then to see how rarely counsel use that as a tool in an interlocutory way. I'm not suggesting that anybody serve me with these if you have a file against me, but you might consider doing it in some of your other files. The kinds of cases or situations where you might consider it appropriate as either an alternative to cross-examining the opposing party or as an adjunct to that is where you have received information that the husband, for example, has purchased a home post-separation, that there's a mortgage on the home, so you know there's a lending institution. You know the name of the lending institution because it's in the financial statement or your client knows where he banks. You serve the lending institution with a summons to a witness on a pending motion with a covering letter that says, we wish to inconvenience you as little as possible. Please call the writer. To that end, it may not be necessary to proceed with the examination. And when I have employed this practice, lo and behold, through the facts comes the net worth statement that the husband has certified accurately portrays his income and assets 2 weeks to the time when he has sworn a financial statement in the legal proceedings with very different numbers in it. And my experience has been when you appear on the interim motion, if all you have are competing statements from the spouses, the court doesn't know who to believe and errs on the side, at least at the initial instance, of taking the lowest number of the payor, being the most conservative approach. But if you're able to go at that first instance with the documentation that supports your payee, your client's position that really there is a higher income than is being stated, you'll I think likely result in having a higher order at that initial stage, which will sort of set the bottom range thereafter. Other examples of where you might consider using it, typically if parties separate, one of them goes out and leases an apartment. It's not unusual to have to have your income certified or disclosed for that purpose. If a car is leased, you have to typically state your income. You might consider getting financial documents from accountants who are not protected by any privilege. You might consider getting banking statements, credit card statements directly from the institution as being a less expensive route than doing what we more typically do, which is serve the opposing party with an appointment to cross-examine. You ask them to bring the documents, they never do. They undertake to bring it, or they take it under advisement. You wait for the transcript, you go to court, you argue, you dicker around, all of which is very time-consuming, and your client during that time period is getting paid a lot less in terms of interim support than they're entitled to. So before the buzzer goes off, that's all I have to say. We're again going to change the order, and Phil Epstein is next going to address you on separation agreements and material change in circumstances clauses.
Thank you, Nancy. Thank you, Nancy, and thank you, Cliff, for changing places. Cliff wants to know what his reward is, and I've told him that LPIC will waive his next deductible. So I'm going to illustrate my topic with a story, and firstly I want to thank my friend Malcolm Crombie for the idea. Although it's his idea, I've developed it considerably further. Mrs. Jones is the wife of a family lawyer. She receives as a spousal and child support for her 2 children the sum of $3,500 per month. Mr. Jones earns $95,000 per year. The parties settled in 1992. Mr. Jones 6 months ago had a serious heart attack. He must stay off work for at least a year, and he must change his practice. He has capital assets such as GICs and RRSPs of a few $100,000, but his disability insurance is his only source of income besides his interest from investments, and that disability income is $3,500 a month. It just happens to equal the amount of support the wife and children are receiving. The husband, as a result of his illness, moves to vary on the grounds that there is a material change of circumstances. On the cross-examination of the husband on his affidavit, he is asked the following questions and gives the following answers. Mr. Jones, at the time of the agreement in 1992, were you overweight? Answer, yes. At the time of the agreement, were you engaged in any form of exercise? Answer, no. At the time of the agreement, did you smoke or drink? Well, I didn't drink during the day, but I did smoke 3 packs of cigarettes a day. At the time of the agreement, had your doctor told you to take it easier, take a holiday, and stop smoking? Answer, yes. Did you ignore that advice? Answer, yes. Were you working in a high-stress environment? Of course. Did your wife tell you that your lifestyle was killing you and that she was not going to stay and watch you have a heart attack? Answer, yes. On that basis, Mr. Jones' application for variation must be dismissed because the Supreme Court of Canada in Willick and LG and GB have now made it abundantly clear that you cannot move for a change of circumstance if the triggering event was subjectively foreseeable. In my paper at tab Q, there is a typographical error, and on page 9, in the second line, I say objectively foreseeable. That should be crossed out, and you should substitute the word subjectively foreseeable, which is significant. Willick and LG and GB are off-cited these days for a number of interesting points, which on their own would make interesting 6-minute topics. But their significance in the area of material change has been largely overlooked. All of the judges in those 2 cases, although they have different views about the issues that they're dealing with, they all agree on one common denominator in the case. And you will find that they all agree with Justice Sapinka when he says in Willick that this means that a change such that if known at the time would likely have resulted in different terms. The corollary to that is that if the matter which is relied on as constituting a change was known at the relevant time, it cannot be relied upon as a basis for variation. So, for example, let us suppose Mrs. Smith is receiving $5,000 a month as support from her husband. It's a large amount, but he earns a lot of money. And Mrs. Smith, some years after the agreement, comes into an inheritance of $2 million because her elderly father died. The $2 million will, of course, produce dramatically more than $5,000 a month, and the husband will want to move to vary to argue that the wife has no need and he ought not to pay. Again, in light of Willick and LG and GB, the application must be dismissed because at the time of the separation agreement, the husband knew that the father was wealthy, old, and was bound to die. And in fact, the richer the father, or the sicker the father, the more subjectively foreseeable the event of his death and the retirement by the wife. Accordingly, if this is the law, and it must be the law, because wise judges in the Supreme Court of Canada have so interpreted the various sections of the Divorce Act and the Family Law Act, which, by the way, have nothing at all to say about foreseeability, but since they have now made it clear in their decisions this is binding on lower courts, you must immediately run to your separation agreements and you must change the material change clause in your separation agreement. And at page Q10, I have given you just the first of what will be many redrafts of the Bar Admission Course separation agreement precedent in order to establish an appropriate mechanism for overcoming the dicta of the Supreme Court of Canada in this area. This clause is designed to make clear that any event, whether it be foreseeable or unforeseeable, whether it be anticipated or unanticipated, is covered off in a material change of circumstance clause. And that is particularly so when it relates to areas such as retirement, which is always a subjectively foreseeable event, or remarriage or cohabitation of the recipient spouse, which is frequently an anticipated event. So my respectful suggestion is that you have a quick look at the paper which attempts to canvass what the current law is in this area, redraft your clauses accordingly, and if you're anyone other than Jerry Sadvari, if you're faced with a variation application in the immediate future, raise this as a defense. Those are my respectful submissions.
Our next speaker is Rodica David on net family property, the inheritance exclusion.
Thank you, Nancy. Firstly, I'd like to ask you to take your pens out because I'm going to give you a citation that is not in the paper. The first thing I'd like to tell you is that there may be some of you here that do not know the background behind Section 4.2 of the Family Law Act. As you are aware, under Section 4.2 of the Family Law Act, assets acquired by gift or inheritance are generally excluded if that happens during the course of the marriage. However, if you acquired an asset by gift or inheritance prior to the marriage, you only get a marriage date deduction. That was a very last-minute change to many drafts of the Family Law Act before it came into force in March of 1986. It was done on the third reading, given absolutely no consideration, and has probably produced some very absurd results. In any event, that is the law, and that's what we're faced with. I am not going to review what I have written in my paper because you can read that. What I'm going to do is concentrate on two aspects of the inheritance exclusion. The first aspect is, when does an asset qualify as an inheritance or gift for purposes of exclusion? And the case law indicates that there's some difference of opinion on this. I can tell you that just the fact that no money has exchanged hands when an asset goes from one person to the other will not necessarily qualify it as an exclusion. In the Black case, which is probably one of the leading cases in this field, and I know one of the counsel in that case is here, the other one will eventually be arriving. But in that case, without going into the very complicated type of transactions that occurred, essentially Mr. Black's father created an estate freeze. Estate freezes are no longer in vogue, although there may be some reasons for them, but they were in vogue for some considerable period of time in order to avoid gift tax. Gift tax has, of course, been abolished now so that it's no longer as significant. Although Mr. Black did not actually pay any money for his shares in the family-owned companies, there was an exchange of shares and there were various estate freeze procedures which the learned trial judge held took it out of the realm of a gift. He said that you cannot structure a transaction so as to avoid gift tax and try to categorize it as something other as a gift for tax purposes, and then when you're dealing with the Family Law Act, suggest that it is a gift. Of course, when all of these transactions had taken place, the Family Law Act was not in force. Another case that deals with a similar situation, and I will spell this, and this is not in my paper, is, I hope I can pronounce it, Karakatsonis versus Georgiou. The spelling is Karakatsonis against Georgiou. It's a decision of Madam Justice Greer, 1991, 33 RFL 3rd, 263. Again, the site is 1991, 33 RFL 3rd, 263. In that case, the wife owned one common share in a private company that had been incorporated by her father during the marriage. The share went to the wife as part of an estate freeze, and by the time the parties separated, it had substantially increased in value. At the time the wife acquired the share, it was valued at $1, and there was a recital that the wife would have to pay $1 for that share. That $1 nominal consideration took it out of the realm of a gift or inheritance, and it accordingly, the full value of her shares were included in her net family property. This was, as I say again, an estate freeze, and it is entirely possible that those cases will diminish in frequency as estate freezes become less popular. But inheritances, there are still many estate freezes in force in Ontario, and they will come up for consideration at some point. A contrary case is the Andreoli case, which is cited in my paper. And in that case, if you're trying to follow my paper, forget it, because I'm not telling you anything about the paper. But in any event, in that case, the husband's mother conveyed to him a parcel of land. And although there were a number of issues in the Andreoli case, the significant issue here was that the land transfer tax affidavit indicated that the consideration was $5,000 by way of promissory note. At the trial, the husband testified that he had never given a note, nor had he made any payments. The mother testified that she had intended a gift, despite the fact that the land transfer tax affidavit indicated that there would be a promissory note and therefore consideration. And the learned judge there, District Court Judge Murdoch, as he then was, held that the husband was entitled to the exclusion. So presumably there will be many more cases that will deal with this issue, but I warn you and caution you that if there isn't an exchange of money, that in and of itself does not take an asset into the exclusionary sections of the Family Law Act. You're going to have to carefully analyze how that asset came into the hands of the parties or the party involved. I want to deal briefly with another aspect, which is the commingling of assets. As a valuation date, an asset can have its origin in many different places. It could be capital, which arises from a gift or inheritance and therefore is excluded. It could be income generated by excluded capital, which is not excluded because, as you know, unless the wording is very clear in the document giving the gift or inheritance, income does not get excluded. Or it could be capital or income unrelated to a gift or inheritance. Let me give you an example. Let's say that as a valuation date, the wife has a bank account that's worth that has $50,000 in it. And a few years ago, she inherited $20,000. Then she deposited some of her income from employment in that. Then the account itself bore interest. And she didn't bother to take any of that money out. Well, if she took none of the money out, it's pretty easy. We know that $20,000 is the original capital. $30,000 is either income by way of interest or from her employment, so the exclusion is $20,000. However, the situation can become a bit more complicated if she deposited funds into the account but also withdrew funds. So let's assume, for example, that the inheritance was still $20,000. The deposits were maybe about $40,000. Accumulated interest was, oh dear. Well, I've barely gotten into my my talk on this area, so unfortunately I didn't have a mirror in front of which I could prepare the talk. So what I'm going to tell you is this: you must assume that your client has to gather all of his or her documents to trace very meticulously where a commingled asset has originated, and then it is prorated. Prorating can have a number of definitions, and I'll save that for my next talk. Thank you.
The next speaker is Jerry Sadvari, creating an exclusion, 6 tips in 6 minutes.
Hi. I'd like to invite you and your clients to play a really fun game with your family and friends. The game is called the Shell Game. I can't claim credit for this. I first heard about it when I was serving on a committee chaired by John Jennings, QC, as he then was, in 1985, when we were looking over the latest draft of the Family Law Act, and it suddenly occurred to him that maybe there's a way to make an exclusion anytime you wanted. Here's what you do. Step number 1, incorporate a shell company. That's still doable within $200 or $300, the budget of almost everyone here, I hope. Maybe not. Step number 2, you must draft a deed of gift. And I'm not talking about one of those thick documents that sometimes one will see, but a 1-paragraph deed of gift. Make sure it has the title deed of gift. Make sure it addresses the share that you're about to gift. And make sure it says that any income derived from that share is also gifted and intended to be excluded from net family property. You can fit all that into about 3 sentences. Step number 3, give this to your favorite child, niece, nephew, or even a friend. Potentially, this will have the effect, if you time it right, and that is time it after they get married, not before, to exclude everything that the corporation owns thereafter. All you need is that 1 share, and you use that vehicle to accumulate your other assets for the rest of your life. That person to whom you've bestowed this gift upon can then choose what regime he or she wishes to share with his or her spouse. I would give you one warning. Don't put the matrimonial home into that corporation unless you have more than 1 share, because as you know, the matrimonial home is not excluded. And if there's only 1 share, when the judge comes along to reflect the value of that matrimonial home, to take it outside of the exclusion and include it in net family property, the temptation will be almost overwhelming to take the whole share because there's only 1. So if your friend or child wants to do this, put the matrimonial home inside, notwithstanding my warning, then there should be further shares issued. The risk there, of course, is that they might not be excluded, so you'll have to warn them that they should do this by way of share split rather than ascribing for more shares. There's always a way when there's a will. Now, the nice part of this is that it can be reciprocal. If you gift your friend a shell company, then your friend can gift you a shell company. I suppose there's a possibility that some judges might think that there's something wrong with this, but I also suspect that that is going to be a more and more remote possibility the longer the company exists, the longer the marriage exists until there's a marriage breakdown. So you should warn your friend that the device may not work if they're going to separate a month or so after they get married, but in the long run, at a minimum, let me be serious for a moment, it gives you something to negotiate with, because until the law is clear on this, and after 10 years it's still not clear, and it may never be because people tend to settle, well, it gives you some ammunition to settle at something better than what you otherwise would. Now, I would like you all to tell me in written form when you put this into effect, and keep me posted as to developments, and then I will share that with you every 10 years and let you know if it's working. And we'll all share the ones that don't work with Phil. There's a kind of, this is one illustration of a mini industry of accountants and lawyers who are trying to find loopholes, have been for the last 10 years in the Family Law Act. And the drafters did their best to make sure there weren't any loopholes, but of course that's impossible. This is a good example. There are others in my paper. I won't tell you in detail about them because they're not quite as much fun as the shell game, but there are lots of ways where you can affect the value, for instance, of assets by entering into shareholder or partnership agreements with others. There are factors that you have to take into consideration when you tie your hands and say, I've now got an illiquidity discount for this asset, like you've tied your hands. But if it's worth tying your hands, then you can go ahead and do that, and you have at least an argument that you have diluted the value without transgressing the provisions of the Family Law Act, in fact, following right within them. And if anyone out there, after reading my paper, knows of any that I've missed, I'd really appreciate hearing from you. Thank you.
The next speaker is Nancy Mossip. The title is How to Get an Excellent Settlement Early and Inexpensively and Pay the Overhead Too.
Well, we've been hearing from all kinds of different tips today, primarily in the litigation field, although there was one on pretrials. Some lawyers get a rush out of court appearances. I would have to say I get a significant rush after seeing my clients successfully sign a good settlement. That's when I feel I've really done a service to the client. It has to be a reasonable settlement. It has to be one that was predictable or could be anticipated from the court. If it's done early and inexpensively, I consider this a real accomplishment. What my paper has highlighted is what I refer to as settlement stoppers, statements that are made by clients that I've heard throughout the years, not always from my own clients, although certainly I've attributed a lot of them to them, that hinder early settlement in a file. I'm going to just go over a couple of them with you now. One of my favorites, but you said. Clients always remember, as you know, the best and most optimistic prediction you gave for their file. That's the one where the stars had to be aligned absolutely perfectly. The lawyer was on drugs on the other side, and you drew the judge from the commercial court.
Sorry.
It's okay, for your motion or your trial. That's the prediction they remember. I believe absolutely that you must tell your client their worst case scenario early and often. You never want your best case scenario or their best case scenario thrown up in your face when you're trying to get them to compromise at a crucial point of the settlement discussions. That doesn't mean to say, and clients often, when you give them the worst case scenario, say, well, you don't believe me or you're not supportive or whatever. There are ways to convince your client that within the four walls, you are giving this advice about the worst case scenario. Outside, when you have to advocate on their behalf or negotiate on their behalf, you'll go for the best. But if you have told them right from the beginning your worst case scenario, their worst case scenario, it's always there in the back of their mind and can be relied on when you really need them to compromise. I must say that I don't think I've ever had a client fire me or complain that I've been too honest with them. I believe we've all taken over files from other lawyers where that's not the case, or I should say the opposite is the case. Another expression that we sometimes hear is that's not fair. I also call this the howling at the moon problem. With the greatest of respect to our no-fault system, damn it, sometimes there is fault. A good family law lawyer facilitates a wronged client's ability to, quote, howl at the moon. If this is in fact necessary, a necessary element to go through in order to get an early settlement. This howling does not have to be, or I should say this howling has to be constructive, it has to be managed, and it cannot be abusive. And I suggest in my ways, I suggest ways in my paper that you can help as a family law lawyer to allow the client that needs to their time to howl at the moon. Another one that I like is when you get the phone call that says, my spouse's lawyer says, and fill in the blanks. Sometimes I don't mind what they say about me. Sometimes I do. But if the comments are directed at you personally, which is a really undermining thing in negotiation, in settlement, the main thing you have to focus on is your relationship with your client. Don't worry about what the other side says about you. Half of it's probably exaggerated, and sometimes it's said just to get to rattle the cage of your spouse, and the important thing is your relationship with the client. And that they trust you and that they don't feel you're trying to rip them off. I also suggest in my paper a couple of things that you can do to make sure that this kind of behavior, that is the undermining of your relationship with your own client, does not interfere with early settlement. The one thing I strongly suggest that we cannot do is fight with the other lawyer about what they might be saying. I believe that one of the greatest settlement inhibitors is two lawyers fighting on a file. And that I also strongly believe that if two lawyers continue to fight on the file, one of them should get off. That both clients there's a disservice to both clients when lawyers are fighting. I also really believe that that expression, that stupid expression we know from a long time ago, that you get more with honey than you do with vinegar, is very true in family law. And I can think back, as I'm sure a lot of counsel can think back, on many a fine settlement that has been reached because of the relationship between counsel. And we can also recall seeing or observing settlements slip from our grasp because of poor relationships between counsel. So if you can't charm the other side and get them to see that the goal is the settlement for the client's sake, then you might think about one of you getting off the file. Some of the other things that I call settlement stoppers are when your client says, just as you're ready to sign, but my spouse is hiding money, I have no idea what I'm entitled to. Another one, I want to know exactly what will happen if I go to court. I also call this the day in court issue. And clients will look at us sometimes and say, I know if I just have an opportunity to tell the judge my side of the story, I know I'll get what I am entitled to. I just know it. What you have to convince the client is that judgments, like settlements, are primarily compromise. The judge, in fact, almost never sees it one spouse's way, unless you've got the miracle case that you've dreamed of all your life. Judgments, like settlements, are compromises, and you have to somehow convince the client that that's the case. Sometimes clients lose faith in your opinion. I dare say they're not losing faith in you, but you as the messenger, they just can't accept the legal opinion you may be giving them about their case. Rather than constantly fighting with the client about the legal advice you're giving them, invite them to get a second opinion. I find that an incredibly facilitating thing to do with your own client. First of all, you'd be surprised. They rarely take you up on it. They rarely go and get a second opinion. They kind of look at you and figure, well, if you're so confident to let me go off and get a second opinion, you must be right. But it stops that level of debate between you and your client. And if they do go off and get another opinion, hopefully, it is consistent with your own opinion, and it will facilitate an early settlement. I know the bell's gone. The rest of a couple of my comments are in there. I bring up one of our old favorites about contents. I know we all like to say I don't do contents, but I just want to remind you, sometimes you do have to do contents. You have to roll up your sleeves, talk about the chandelier, because your client can't get past those issues without seeing the big picture. So you can talk big picture, they want to talk the chandelier. Just remember that. And then I talk about how you can make money doing all of this, and my last comment is, I don't believe a successful family law practice has to be litigious. In fact, I believe the exact opposite. And I enjoy what I do in settling. Thanks.
The next speaker is Carole Curtis, Tips on Costs.
This format is so intimidating. I actually bet Susie Goodman that I could say more words in the 6 minutes than she did, because I have about a 20-minute speech I want to fit into 6 minutes. What I've given you is precedents, not a paper. I want to talk about costs in this sort of new era we're in right now, which is a very difficult era. And I want to talk about them really briefly from sort of two perspectives. One is why we should be asking for them, and the other one is what to do to get them fixed and to get the right amount for your client. The justice system now is a precious resource, and one that is ever decreasing, and we need to do our business differently. We need to move away from the notion that family law has no cost consequences. This results in kind of an implicit permission for parties to litigate without consequences, is what I call the litigation pig mentality. Cases that go on and on and on with no merit, and no judge will just sit there and say, I'm awarding costs because this case should not have gone this route. I want you to know that I gave this speech to judges actually this year, urging them to take control of their process and award some costs. And of course what they said is, nobody ever asks for costs. So let's ensure that the cases that get to court and take up the court time are the ones that need court time and deserve court time, and that frivolous cases don't use up the court time that is increasingly less available. The big example that I can think of is the custody case that really has no merit, that is put forward because it is and becomes a bargaining chip in all the other issues. And all of you who do that and have done that and are guilty of that know who you are. The other issue I want to talk about just briefly on costs is legal aid. Why is it that when we have a client on a legal aid certificate, we think we don't have to ask for costs? Now, some of us here are old enough to remember the days when we used to stand up and say, the nature of my retainer obliges me to ask for costs. Which is really horrible and demeaning and inappropriate, demeaning to your clients and to the process. Frankly, when you're on legal aid, it's not free. Somebody's paying for it, and in most cases, we're paying for it. I pay $220 an hour every case I take on legal aid, because that's the difference between what legal aid pays me and what my private clients pay me. So those are the cases that you should especially be asking for costs, not sitting there and saying, oh, somebody else is paying, I don't have to worry about it. The new family law rules are going to give us a whole new world about costs. Yes, there are going to be family law rules this decade, this century. They're probably going to be out for discussion in the summer or the fall. And the prime directive is basically going to be that costs shall follow the event generally, with very little discretion on the part of the judges, and bearing in mind the conduct of the parties and the reasonableness of the parties. And costs are going to be defined much more widely. They're going to include your client's out-of-pocket expenses to come to court, like the babysitter, like the day off work, like the train ticket to get there or the bus ticket to get there. And they're going to be fixed. So it's intended to be part of a family law case on a regular basis. So what should you be doing now? You should be asking for costs a lot more often. And you should be prepared to argue the two parts of costs. You should be prepared to argue the award of costs after your motion, and you should be prepared to argue the amount. If you're not prepared to argue the amount on the same day that you argue the award, that's fine. Put it over for a week or so. But after you finish your motion, especially if you've made an offer to settle, you should be all ready to go to talk about why you should get costs. Motions, I just want to say quickly, orders where costs are reserved to the trial judge are no good in family law. No good. Because there is no trial judge in family law, ever. So you want to get costs of the motion and you want to get them fixed. And the questions are, should this motion have been brought, and should this motion have been settled? Now, I just want to tell you quickly about the precedents that I gave you. I changed the names to protect the innocent, of course, except for my name. And these were two variation applications, which I think is sort of the bane of family law. About a third of our practices are variation applications, some of which are totally without merit. One of these variation applications was dismissed in its entirety. It was a half-day trial. I got $16,000 in costs from a provincial judge. That was appealed. The dismissal was appealed, and the costs were appealed, and all of it was upheld on appeal. So and this client was a legal aid client on a contributory certificate. So what's the lesson? If you ask for it and if you prepare properly, you get it. And there's no reason that that guy shouldn't have paid costs. The entire variation application was dismissed. It was entirely without merit. I'm now, and that's the Smith precedent. I give a lot of detail. I set it up to the judge in the context of how much work was done for each court appearance, if you go through the way the precedents. I set up my disbursements separately. I should tell you that I always get 100% of the disbursements I ask for, especially when I present it like this. I've never had the other side even raise a peep about it. I present it in all nice computer organized categories. My law clerks do this for me, and I check it and we sort it out. The other one, the Shea case, was also a variation application. I'm almost done.
5 minutes. You got one
That's
more.
my 5 minutes? Oh, that's nice. So it was also a variation application, also without merit, but the Shea case did not go to trial. The Shea case settled before trial. This case is under reserve right now on costs. I was awarded costs, and I have asked for $40,000 in costs. And this is again a provincial division case, and I'm telling you, I feel confident that I will get somewhere between $20,000 and $30,000 in costs in this case. This again was a client on a legal aid certificate, but she's an employed person and she is fully contributing to her certificate. And again, if a case is brought without merit, in both these cases I put in offers to settle, and in both cases the offers to settle obviously were better than or as good as the results. So all you have to do is ask for it, and it shall be there. Do the work, prepare the documents, make sure the judge knows how much time you spent, and you'll get your costs. This is the way of the future. We cannot afford to continue litigating the way we are now. Nobody can pay for it, not our private clients and not the legal aid plan. I'm done. Thank you.
Suzanne Goodman Carroll's the winner. Substantially, about 200 more words. The next speaker is Cliff Nelson. When and how to appoint a receiver manager in matrimonial matters.
I always get tough acts to follow. I'm just really feeling terrific about the fact that for the next 4 or 5 minutes I can tell you that I'm Phil Epstein and you're not. At least that's what it says in the program, and I've wanted to say that for a long time. One comment I want to make, and it has absolutely nothing to do with my article. Many of us often run family law actions and divorces simultaneously. I would ask you to get a hold of a copy. If you can't find it, I guess you could call me, of a case called Miller and Miller. Very important. The Ontario Court of Appeal has said if you run your divorce before you run your family law action, parties become divorced, your client will lose the right to claim exclusive possession. So be very, very careful about that one. As far as the appointment of a receiver manager is concerned, like many of you, I get awfully tired of chasing recalcitrant husbands. You feel very sorry for your client, and then of course what happens is that the bills mount and you get into very ugly matrimonial cases. And just a short while ago, it might be an elephant gun approach, but I was acting for a wife who wasn't being paid interim support. The long and short of it, and I found it very easy and extremely effective, was that I moved to strike the husband's pleadings. I was successful. The case went on. There was an undefended trial, and at the trial, when the trial concluded, because the husband had disobeyed all court orders and was a man of means, I asked for the appointment of a receiver manager. Now, this husband may be a little atypical for some in that he was a man of means, but he had shares in a private company, and he channeled all his income through the private company. So my recollection is he had debenture income, a considerable amount of it. He had mortgage income, and I think he rented a condominium in Florida. So there was must have been about a $15,000 a month cash flow moving into his privately held company. Rather than leaving things to the family support plan, rather than going to court and getting contempt motions, or that never seems to work very effectively for a variety of reasons, the receiver manager was appointed. It literally, I issued and entered the order, and that's part of your material, by the way. It literally took 1 day. As soon as I got the order, I gave it to the receiver manager. The receiver manager went in and took over absolutely everything, and the cash flow went into the receiver manager's hands, so much so that the husband had to call the receiver manager and ask for $30 to buy gasoline for his car. Needless to say, the case then went into very, very serious settlement negotiations. Now, There is a form of order in your materials. There's also one in the rules. I'm not an expert in receivers. You can tailor make the order to your own situation. You have to get the consent of the receiver manager, obviously, and if there's money in a case, you just go to the big accounting firms. They all have them, whether it be Deloitte's or Ernst Young, whatever. I don't have too much to add. I've got a very short article, but the importance is please take a look at the precedent, and when you have a case where you know that enforcement is difficult, give it some thought. I mean, garnishment's not going to work, so you should really give it some thought, because I think in the 20-odd years I've been practicing family law, this has been one of the most effective tools I've used. One word of caution: I didn't plead because I didn't know when I started the case that I would need a receiver manager. Things got progressively worse. The lawyer on the other side made an issue of that. I don't know what the answer is. It seemed to me that one doesn't need to ask in a pleading for enforcement. I mean, you don't ask for garnishment. Why should you have to ask for the appointment of a receiver manager under Rule 60? But it's something that you might want to consider if you know the lay of the land right at the beginning. Thanks for your time.
The next speaker is Judith Nicoll, Appeals a Roadmap.
Thank you, Nancy. I have in my paper touched upon the procedures and the timing for launching an appeal in any of the appeal courts, and I'm not going to take you through those charts that I have included as addendums to the paper, except to point out that they're all in your Ontario Annual Practice and your Ontario Civil Practice, where they're quite invaluable tools to get the shorthand version of where you're supposed to be, when you're supposed to be there, and what it is that you have to file. I would like, however, to talk today, in the short time that I've got, about the threshold issue of whether or not one ought to bring an appeal at all in family law. The case law makes it very clear in the area of interim appeals that you just really ought not to do it. The likelihood of success on an interim appeal in a family law matter is pretty remote, from the case of Cipher and Cipher to the more recent Langevin case that are both cited in my paper. The court has confirmed that the courts have confirmed that they're not likely to interfere with an interim order unless it's clearly wrong and, to borrow their language, exceeds the wide ambit of reasonable solutions that are available in a summary proceeding. We're all painfully aware of what that wide ambit might include, and that is part of what makes our job so difficult on an interim basis. But unless you're able to show some extraordinary circumstances, it is likely to be an extreme bad use of money to bring an interim appeal on behalf of your client. The far better use in the face of a bad interim order of both time and money is to press the matter on to the next stage, preferably in the form of a case conference or an early pretrial, when you can hopefully get someone to intervene, although regrettably in the case conference incident it's likely to be the same judge who made that bad order. But in any event, if you are as a respondent obliged to participate in an interim appeal, just as you've heard already from Carole Curtis, it becomes imperative that you are prepared to argue costs at the time of that appeal. The courts and the appeal courts are very much in a mode of streamlining their processes, and they are happy to contemplate fixing costs provided you tell them what it is you're looking for and why it is you want it. And so it's very important to make sure that you have a reasonable basis for providing the judge with an accurate reflection of what your costs on the appeal have been. With final family law orders, it's likewise very difficult to get the appeal courts to interfere with the decisions, but certainly there has been much more success in that area than on an interim basis. The areas which have marked the most, which have shown the most activity, continue to be in the mobility area and in the spousal support area. There is many cases right now where spousal support is being reviewed, both with respect to duration of support, quantum, and as well the method of payment. There's an awful lot of appeals with respect to whether or not a lump sum of spousal support is an appropriate method for payment. It continues to be a complex and complicated area, and one wonders whether we might not be better served with some spousal support guidelines, because it's really very difficult to advise on, and with only 4% of the Supreme Court of Canada's cases being in the area of family law, it's unlikely that we're going to get any clarity anytime soon. When you are proceeding on an appeal to the Court of Appeal, it's imperative to be aware not just of the rules and the Courts of Justice Act, but also of the many practice directions which the court has over the years issued, and which they are more rapidly issuing as a part of their process to make the Court of Appeal more user-friendly. They have all sorts of wonderful modern techniques now that they're providing, including video conferencing, argument by written materials only, and also telephone appeals, all of which are available in certain conditions and upon motion to the judge. I've set out with my paper a copy of the most recent practice direction from the Court of Appeal, but if you are faced with the opportunity for an appeal to the Court of Appeal, the first thing you might want to consider is to make sure that you're very familiar with the most recent practice direction, and it's not the one that you threw out in your ORs last week. For example, there is a pilot project that's just was to have ended on April the 1st, 96, and it's been extended, which provides that any motions for leave to appeal are now to be argued in writing, and that rule is going to be extended because the project has been so successful. The court has also provided detailed directions with respect to what your records are to include, as well as the fact that you are obliged to provide what your estimate of time is going to be. And there are particular provisions with respect to appeals from summary judgments as well. This is an interesting area, something that we're not all that familiar with perhaps in family law. There's a unique body of case law with respect to appeals from summary judgments. But we don't, as a rule, we haven't been that familiar with summary judgments other than in the granting of the divorce itself. I would expect that that may well be another area of growth in our practice, because it appears that more and more of the judges are using the mechanism of the summary judgment to deal very expeditiously with determinations of family law issues, as was recently seen in a decision at the provincial court by Judge James, by Justice Beaulieu, in the AE and AA case, and also at the Manitoba Court of Appeal in the Achenbach case. There is presently one summary judgment appeal that I'm aware of in a case called Schmegner, an appeal from summary judgment of Justice Greer that's been perfected to the Court of Appeal, and that's where she refused to set aside a separation agreement on a summary basis. So I think, as we're all faced with cost cutting and the court's cost cutting, we may well be seeing more of these types of appeals. Thank you.
Thank you, Judith. The next speaker is going to be Tom Bastedo. Again, there's a small switch in the order on common sense advocacy and family law.
Nancy Backhouse wrote to the speakers and said that the most common complaint from the registrants in programs such as this is that presentations are too basic. I have ignored that letter, and my presentation is really basic. Our trade is advocacy, and many think that advocacy in the family law courts, to be blunt, is poor. There are many reasons for this, and while the reasons are beyond the purview of my comments, I want to make simply 5 observations which might be of assistance. These observations generally follow the development of a case, and as I say, are basic, but I make no apology for saying they're basic, and they bear continuous repetition. First, not enough time is spent gathering facts, documents, and information at the beginning of a case. Every lawyer thinks that he or she has sufficient information, and most of those lawyers are wrong. This is a common complaint by those who deal with lawyers, whether they be investigators, judges, social workers, or clients. And it is absolutely essential to spend the time to gather a familial structure, an historical background in which the case is set, a documentary infrastructure, and it is necessary to organize the information properly to put it in binders and have it available to you where you can find it, whether that be on a computer or notepad. It doesn't make any difference. Secondly, it is necessary to have a plan. You will call on the usual suspects, the man with the plan. In his excellent review by David Wingfield of the book entitled America's Top Trial Lawyers in the recent Advocate Society Journal, there's a fascinating excerpt where a large commercial case was won by a cross-examination on one out of thousands of documents before a jury. That lawyer had a plan which he was able to develop at the beginning of the case because he had the factual background to do so, and he stuck to the plan throughout the development of the case. Without a plan, it is impossible to make important procedural decisions. It is impossible to decide when to interview collateral witnesses. It is impossible to plan what sort of examination to conduct, and it is impossible to conduct and draw adequate pleadings. The plan has to take into account the factual information which I have said is necessary, as well as the client's personality, and to assess what is reasonably possible in the circumstances. Third, the plan must put forward some sort of solution. One of the problems in our practice in family law is that most of the cases are impossible of a reasonable solution, but advocacy without solution is advocacy without purpose. Because it is the trier of fact's job to effect a solution, it is necessary, obviously, for the advocate to present that solution, your solution, as the preferred solution to the trier of fact. Again, that solution, will follow the plan which is drawn from the facts and the historical substratum, and ideally will be one which the trier of fact will wish to adopt. If this plan is presented in negotiation, it must have logic and compellability and draw from the background which I have described. Fourth, in putting forward a solution, it is necessary to summarize to a truly astonishing degree. We live in an era of cost consciousness, of sound bites, of USA Today, and our society is used to this sort of presentation. We are threatened with advocacy by ticking off boxes because we are inundated with discursive and incomprehensible pleadings. An intermediate step which will suit both those which would confine us to advocacy by ticking off boxes and which will satisfy those who deal with 30-page affidavits is to present legal and factual material in short, one-page memoranda. These memoranda can be summaries of evidence from affidavits or transcripts. They can be linked to the law. They can be put in graphic form. They can be used to convey basic factual and supportive information, and they can be handed to a judge in argument or to opponent in negotiation. It is essential to espouse accuracy, and if you lose your reputation for accuracy and integrity, then these memoranda lose all efficacy. Hopefully, the trier of fact will absorb what you are saying and see what you are putting before him or her and come to what is the common sense solution which you have thought up because you have a plan and because you have the facts and the knowledge to put it forward. Last, at the Canadian Bar Association in January, Mr. Justice Carnois spoke of advocacy from the perspective of a judge. What I say is not to be attributed to him, but you would be amazed to learn just how much judges depend upon the integrity and the presentation of the lawyer and how much it affects the result. It is absolutely essential that the judge have confidence in being able to rely on you. In our practices, we have little opportunity to engage in advocacy in the traditional sense because the courts and the clients do not have the time. We must adapt our advocacy to the era in which we practice. This era demands a mutual dependency between the lawyer and the judge, and it insists upon the maintenance of traditional courtesies. I simply state to you that the advocate who interrupts one's opponent, who is careless in the presentation of fact or law, or misuses evidence deliberately, who is not prepared to put forward a concise, accurate summary of a solution which is prepared upon the basis of a well-thought-of plan, in facts which are articulate, clear, and based upon research and effort, that advocate is going to founder on the shoals of defeat, and is not going to be able to serve his or her client. Thank you.
Our last but not least speaker, Stephen Grant, on fair market value, the case of wine.
I actually don't intend to talk about fair market value, but I do intend to talk about a case of wine. Already? Next already. We have to consider whether we're looking at a case of wine as a fair market value or fair value. And the question then becomes, can our case of wine have any market value at all? It's an offense under the Provincial Liquor License Act to sell bottles of wine or cases of wine without a license. So then if the wine doesn't have a market value, does it have an exchange value? And you have to consider this issue seriously, and then you have to consider that it's a serious waste of time, if not the wine. However, forget all that for a minute, and let's assume that we have a case of wine and we're considering it as a fair market value, on a fair market value basis. You have to then consider a number of potential discounts. First, illiquidity, and this will depend on the level of sedimentary deposit in the bottles themselves. The more sluggish the wine, the greater the discount. Then there's inferiority. This really suggests a lack of care and control if the wine isn't properly temperature adjusted and maintained, or if it's some crummy year wine, or perhaps if it's a Californian wine that has a Gallo label on it. Then there's the blockage discount, and this has a couple of different interpretations, but most importantly is if the cork becomes stuck while opening the bottle, this blockage discount might occur, and a discount will apply to this. Breakage, you can consider a breakage discount when the value of the wine is greater the less that's consumed. And finally, we might want to consider the aesthetic discount. This depends on whether you or I am drinking the wine. If I get to drink the wine, you get the discount. So that's wine on a fair market value basis. Let's look at it on a fair value basis. The question then becomes trying to quantify the subjective enjoyment the owner could derive from the drinking of the wine if given the opportunity. It's a little illusory because if the owner of the wine is given the opportunity to drink it, there won't be any asset to value on valuation date. So turning to fair value, that subjective element really has to invites a further question, and that is whether there is some illiquidity discount factor, and we have to look at the wine on a breakup, or more specifically, a liquidation basis. That's the consumption method. Since we're discussing a liquid, we have to consider the actual consumption of this wine, and we want to look at this on what I call a capitalized yearnings approach. This really is the overwhelming desire for that one great swig of the wine, and in a good vintage you might want to have, this might be 5 times yearnings, maybe 6. So in short, as I said at the outset of my paper, we might want to just consider dividing the wine in specie. At that point, you have to determine who's going to get more enjoyment out of it and make an adjusting payment, it seems to me, from one to the other. But it's Friday afternoon, and I think time for a preprandial libation. Thank you very much.
I'd like to thank all the speakers and thank all of you for your commitment to continuing legal education for staying so long on a Friday afternoon.